In today's video, I'm going to talk about something that sounds almost absurd on its face. But what if you were sued by a debt collector and you didn't even know about it? My name is John Skiba, and I'm an attorney in the state of Arizona, and I help people who are dealing with serious debt problems like judgments, debt collection lawsuits, and bankruptcy. And today I want to talk about an occurrence that happens all the time. Here in my law practice in Arizona, I meet with people who are being sued by creditors, but you would be surprised at how often people come into my office. They're getting hit with a wage garnishment or a bank levy, or there's a lien on their home, and they weren't even aware that a lawsuit had been filed against them. Now, you may want to say, "Hey, how could that actually happen?" It happens frequently, and the reason is what's called process of service. Once a lawsuit is filed by a debt collector with a court, they then have a certain period of time to serve you with a complaint and a summons. This is super important because this gives you the notice that you need to be able to file a response with the court. Now, if you get sued by a creditor and they serve you and you don't file a response, the court will enter a default judgment against you. Essentially, the court's saying, hey, look, if you're not going to respond to this, we're going to assume that you agree with everything that the creditor is saying and alleging. And so we're just going to give them everything they're asking for, plus attorney's fees, plus court costs, plus interest, and the whole thing gets out of control. But what happens in a lot of cases is that very first step, service of process. They do not give people proper notice of the lawsuit. And so because of that, that results in a default judgment being entered, and you end up with wage garnishment, bank levies, liens on your property, and you weren't even aware that the lawsuit had been filed. Let me give you three different options. If you find yourself in that situation where there's a judgment that's been entered against you, but you weren't even aware of how it came to be.
Consumer warrior is on your side. The consumer warrior.
The first thing you do, step number one, is you need to get a copy of the entire court file. Now, you can go down to the court and ask for a copy of the file. You can also, some courts will do it online, or they'll even email you the documents. And you're going to be looking for a very specific document in that court file. It's called the certificate of service, or sometimes it's called an affidavit of service. The way that this procedurally works is once a creditor files a lawsuit against you, and then they serve you with a copy of the complaint and summons, the process server, the person who actually brought the documents by, they have to go back to the court and file a document, the certificate or affidavit of service, that states exactly who they served, when they served, what day, what time, all that kind of stuff. And it's surprising. The affidavit of service, it gets very specific. It'll say, hey, they came by your house on December 1st, 2025. They served, and they provide the name, who is 6 feet tall, has brown hair, and weighs 165 pounds. I mean, they literally get into that much detail. They provide the address, the time of day. All those details are included in the affidavit of service. And the reason why this document is so important is because you can read on there what they told the court that made the court believe that you had been properly served. Now, in most states, service requires that they actually serve you in person at home, or alternatively, that they serve someone who lives there with you of suitable age and discretion. Most courts don't define what suitable age and discretion is, but do teenagers count? Unfortunately, yes. But usually, an 8-year-old receiving service does not count. But the key here is it has to be someone who actually lives with you at your residence. They can't come by your place and serve somebody who's just there visiting for the weekend or something like that. It's got to be someone who actually lives with you at your residence. What we will see oftentimes is the creditor will actually file the lawsuit, and then they'll try to serve you at an address that maybe you don't live at anymore, or they try to serve you based on an address that was on the credit card statement, something where you're not actually going to get notice. And if they can't serve you personally, they can actually go to the court and ask for permission to do what's known as alternative service. If the creditor obtains an alternative service order, that means that they can serve you in whichever way the court allows. They can do it by posting a copy of the complaint and summons to your door. They can do it via email. And in the old days, they would even allow them to put it in the classified section of a local newspaper where no one would see it. So that's why you see sometimes these judgments get entered, even though they're telling the court, hey, we served them properly. You get that affidavit of service from the court, and the first thing you're realizing is, hey, they didn't serve me. They served me at an old address. They served me at a bad address. They served a person who I don't reside with. All those kind of things can go into play. If you have that situation where service of process was not done correctly, your first option, number one option, is to file a motion to vacate the default judgment. In most jurisdictions, the law says, look, if the plaintiff or the creditor, if they don't take that first step correctly, everything else that follows is void. But you have to file the motion to vacate the default judgment with the court. So you filed it, and then you have to prove that they didn't do service correctly. The judgment's already been entered, and so if you, as the defendant, are filing a motion to vacate the judgment, the burden is on you to show that you didn't get served properly. Sometimes this can be difficult, because you're thinking, I'm trying to prove a negative, prove something didn't happen. This is where you can get creative. You can go back and look at old lease agreements, utility bills. One time I even got a default judgment set aside by proving that my client couldn't have been at home where the process server alleged to have served them because they were at a wedding. We used Facebook posts. We actually went back, got copies and printed them off, showing that my client was not even in the state of Arizona at the time that this creditor was alleging to have served her. And because of those Facebook posts, we were able to unwind that. Social media is a powerful tool. If you look back, you're kind of surprising, maybe shocked how much information we actually have online about us. But if they said they served you at a specific date 5 years ago, and then you go look on your social media and you're like, there's no way they could have done that because I live somewhere completely different, that can be evidence that can be used to prove that they didn't serve you correctly. Now, it's important to understand if you file a motion to vacate and you're successful, the court vacates that default judgment. It is something where the lawsuit's not dismissed, but it takes it back to step one where you can file an answer. And particularly if you're dealing with like a junk debt buyer, debt collector, somebody like that, you may be able to file an answer and litigate the case or put it in a better situation to settle for less than the amount owed. And that leads us actually to the second option if you find yourself with a default judgment against you, even though you didn't know that the lawsuit had been filed, and that is you can try to settle the judgment. This tends to be more effective if the default judgment was entered just recently. There hasn't been a bunch of interest accruing on it. But here in my practice in Arizona, just recently I had someone call in. The judgment was over 15 years old and had been accruing interest at 18% over that entire 15-year period. So trying to settle that was going to be difficult because the amount, even though the judgment was small when it was first entered, now it was 5 times as large as when they actually first submitted the judgment to the court for signature. And so it's something where settlement early on, especially, you could reach out to the creditor, offer some type of proposal and see if you can get a payment plan, a reduced balance, lump sum, whatever it is that you can actually do. You can reach out and try to get it settled that way. Again, I recommend you do that quickly if the judgment was recent. If it's super old, you may need to file that motion to vacate the default judgment to put yourself in a better situation overall, to have more leverage to get a lower settlement. So the first option is to file a motion to vacate the default judgment. The second option is to settle it. The third option, which I give everybody, is you can file bankruptcy. If there's a default judgment that has been entered against you, you could file a Chapter 7 or a Chapter 13 bankruptcy and typically get rid of that judgment, get rid of the underlying debt. And also, the bankruptcy will stop the creditors from making any type of collection activity against you. So you're not going to get garnished. They're not going to be able to lien your home. They're not going to be able to levy your bank accounts. It's going to stop everything. So a bankruptcy, kind of the nuclear option there. If you're like, look, I've got this that I'm dealing with, and I got 6 other credit cards that are in default. I need some debt relief here. You can file the bankruptcy and it will get rid of that collection lawsuit and the judgment completely. So hopefully that helps if you find yourself in the situation. And again, more common than you would ever think that you can actually get sued in a court, get a judgment entered against you, and at the same time, not even be aware it happened. It happens all the time. And it's because of the way that the debt collection industry approaches service of process. Don't ever just take their word for it that they served you appropriately. Go to the court, get that affidavit or certificate of service, look at the details of it, look at when they served you, what the address was, who they served, all that kind of stuff, and then go back in your files and see, is it true? Surprisingly, a lot of times it's not true. And so I would recommend that you do that. Take those steps, take control, but don't ignore it. The longer you ignore it, the more interest accrues and the harder it's going to be. But if you take those steps, you're going to be able to get this thing dealt with once and for all, get it in the rearview mirror, and get your fresh start. Thanks for watching today.
Consumer warrior is on your side. The consumer